Coming to the legal world, foundation presents the law of arbitration in India. First, what is arbitration? Arbitration is an alternative dispute resolution method where disputes are resolved outside of the court system. Now, the difference from litigation: unlike litigation, arbitration is a private process where parties agree to submit their dispute to an impartial third party who renders a decision which is typically binding. Now, what is an arbitration agreement? It typically consists of intent to arbitrate, scope, arbitrator selection, procedural rules, location, language, governing law, costs and fees, enforceability, waiver of court, and proceeding. Now, let's move on to the history of arbitration in India, starting with the Arbitration and Conciliation Act of 1996. The historical context is that it's the modern legislation that governs the arbitration in India. It replaced the outdated Indian Arbitration Act of 1940. It was a significant overhaul of India's arbitration laws, bringing them in line with the international standards of the best practices. It aimed to make arbitration a preferred mode of dispute over the years. Next, the Indian Arbitration Act 1899. It has a historical context in the important piece of legislation which was introduced during the British rule in India. It was applicable throughout the British India. The legacy that it carries on is the foundation for India's approach to arbitrations. Many of its provincials influenced the later Arbitration Conciliation Act 1996. It also established a clear procedure for arbitration. Next is the Bengal Regulation Act 1772. It provided a legal framework for the resolution of disputes through arbitration. It recognized the arbitration as a means to settle the commercial disputes, particularly those related to trade and commerce. The Act also allowed parties to refer their disputes to arbitration voluntarily, and the decisions of arbitrations were binding. Now, how does it specifically help India? Does arbitration really uplift the India's conciliation? Well, let's see.